So now we need to take a look at these freehold tenancies. Freehold tenancies. Now, first of all, if you think back, we talked about 4 terms or definitions right at the beginning of these different types of estates. One of them was tenancy, and if you recall, y'all, tenancy actually means or has 2 different definitions, right? If we're referring to freehold, obviously tenancy now means how the land is held. In other words, is it just one owner, or could there be, or are there multiple owners of the property? That's what tenancy means, and at least with freehold estates. Again, it changes a little bit with non-freehold, and that's coming up here in a little bit. But let's look at the different types of freehold tenancies. Now, keep in mind, as a potential purchaser of real estate, this is something you will have to make. You'll have to make a decision. How do you want to own the property, or what type of tenancy do you want to own the property in? Okay, so y'all, this is really important. But now let me say this too. This gets sort of into some legal areas. Okay. And my point being, y'all, should we as real estate agents ever be giving our clients legal advice? Absolutely not. So, y'all, you need to understand this, certainly for test purposes, but also from a more practical sense when you're out there working with your clients. If you understand it, at least now you can assist your clients, at least in terms of helping them ask the right questions. Y'all, this is something every buyer you work with, they need to talk to the attorney about tenancy. Which type tenancy do we want to own this property in? Because I will tell you, it matters. And quite frankly, it could be a big deal. And unfortunately, most people never even get into this. They never discuss it with the attorney because the buyer doesn't know it. Okay? The agent is not representing them well. But y'all please hear me here, you should not even suggest to your client that, oh, look, well, you've got this scenario going on, you need this type of tenancy. Y'all, that you're now practicing law. That's a no-no. But you can at least let them know, look, here are some options you have, and depending on which one you decide to go with is going to matter, okay? They work differently. So I recommend you might want to make a phone call to your attorney, whoever's doing the closing, and let them explain to you the difference between this type of tenancy versus that type of tenancy, and make sure that you and or your spouse, if that's the case, make the right decision, okay? So, yes, you need to know this stuff, but not so that you can give advice to your clients. That is not the point here. You certainly know it for test purposes, but this is not something you want to give advice for. Okay, so let's take a look at these different types of tenancies. Y'all, you could own the property in severalty. Severalty means one. Severalty means one. So if the person purchasing the property is just one owner, y'all, there are no other owners to this transaction, then it will be a tenancy in severalty. Y'all, not a whole lot to discuss there if there's just one owner, okay? But if it's not in severalty, if you're not buying this property in severalty, that means there are multiple owners, at least 2 or any amount above that. Y'all, multiple owners, at least 2 or more owners. Y'all, that's when it can start getting tricky, okay? And we're going to take a look at this. The first is the tenancy in common. And y'all, obviously with this type of tenancy, that means there are multiple owners, at least 2, could be more or any number, but at least 2 or more. But basically, y'all, here's what you get as tenants in common. Y'all, let's say it's a husband and wife. That's usually the most common time you have more than one owner or two owners. It's usually husband and wife. Doesn't have to be, I get it. But we're going to assume we got a husband and wife buying this property together. Well, as tenants in common, that means each owner, both husband and wife, will receive their own title. Okay? Probably be a 50-50 ownership, but it doesn't have to be with tenancy in common. You know what? Let me give you maybe a better example to make this a little bit easier. Y'all come back to the husband and wife here in a little bit. Y'all, let's say we have some investors wanting to buy a property, fix it up, sell it. Whatever they're going to do is they're investing in the property. And let's say it's three owners. In fact, I'm one of them, and I've got two partners that we all want to go. The three of us want to go in together and buy this property. Well, as tenants in common, again, we could all have equal amounts of interest. Y'all, you can do that. But it doesn't have to be equal. Y'all, we could have different amounts of ownership. Y'all, for example, I may decide to have 50% ownership, but my two partners will have 25% apiece. Okay? Obviously, it has to equal 100 between the owners, but it doesn't have to be an equal amount. Y'all, that is the key to tenancy in common, and especially for test purposes. You've got to remember that. Write it down, highlight it, whatever you need to do. With tenancy in common, you can have unequal shares. They do not have to be equal. That's critical. The next thing is saying is that the estates can be inheritable. Y'all, meaning this, y'all, so say, again, it's me and my two partners on the property. I die. Can I leave my interest to my heirs? To my kids, my wife, whatever? Yes. Well, why is that? Well, do the other partners have any say-so in what I can or cannot do? Because we're all partners. Not under this type of tenancy. With this type of tenancy, we all three have our own title. I'll receive title that shows Frankie owns 50% interest in this property. My partners, they'll have their title showing they own 25% interest in that same property. Now, obviously, I can't do anything to affect their interest, but they can't do anything to affect my interest. So I can do whatever I want to do with my interest as tenants in common. So I can leave my share to my heirs. I could sell it if I chose to. We could do that. Now, this last bullet is saying in case of a dispute, owners may have to file a petition to force the sale of the property. What they're talking about there, even though I have my own title, the legal right to dispose or sell my interest if I choose to, could my partners just really be up in arms about what it is I'm actually doing with my share? And to the point, they could try to sue to prevent me from being able to dispossess or dispose of my property. Anybody can sue anybody for any reason. And what they're saying here is the courts would then petition the property, which, and I will tell you, this applies it's a lot more significant with the next type of tenancy we're getting ready to talk about. But if they should ask you on the exam, what must partners or multiple owners do if they have a dispute over how one party is trying to handle their interest or not? Then you've got to go to court and ask the courts to petition the property. In all reality, it's already been petitioned under this type of tenancy. So really, it's just a legal action. We'll talk more about petitioning here in just a second. So let me just hold on to that. Otherwise, I'm going to confuse you. All right, but that's what tenancy in common is. Remember, what's the main thing you need to understand about tenancy in common? You do not have to have equal shares. They can be unequal shares between the owners. Okay. The next option you have is joint tenancy. Again, this involves multiple owners, 2 or more owners. But with joint tenancy, there is no division. You cannot divide up the interest unequally. In fact, the way the law reads here, in this example, me and my 2 partners, all 3 of us in essence become one. Because now under joint tenancy, there's only going to be one title. Each owner will not get their own title. There's only going to be one title, and it will list whoever the partners are. In my example, there's 3 of us. So it'll list all 3 of our names, and it will state that all 3 own the whole property. So it's not like I get more than they do or they get more than I do. We all own equally. We all become one. We all own all of it together. Okay? There is no division of interest in joint tenancy. I'm telling you, you better remember that. With tenants in common, you can divide up the interest. But joint tenancy, you cannot divide up the interest. That's a no-no. You just can't do it. Now, you'll also notice, there's a kind of a phrase here talking about the right of survivorship. That's another key component of joint tenancy. It must state, and it'll state in the deed, that this tenancy comes with the right of survivorship. So what does that mean? Well, again, in the example with me and my 2 partners, if I die, can I leave my interest, whatever I had, to my heirs? No. Because I don't own any specific interest by myself. We all own it together. We all own all of it together. But because of this right of survivorship, that means if one owner dies, the remaining owners now own all of it themselves. So obviously, at some point, more than likely, I guess we could all die at one time. That's possible. But most likely, sooner or later, there's going to be one person left standing. I might die first, and one of my other partners will die later, and then now there's one more left. Well, guess what? That one person now, because of the right of survivorship, now owns all of it themselves. Now, that's kind of interesting, isn't it? Because, and then once all partners die except for one, we no longer have a joint tenancy. What kind of tenancy do you have now? Because there are no partners. That's now the tenancy in severalty, meaning now there's only one owner, and basically now they can do anything they want to do with it because there's no other partners. Okay? That's the right of survivorship. Now, a couple key points here about owning or purchasing property as joint tenants. It says all owners must acquire the property at the same time. Again, we all buy it at the same time. You can't come in later. Got to use the same deed. There's only one deed, one title. We all acquire equal interest and we share equal rights. In essence, we all become one. That's what they're talking about here as joint tenants. Now, let's talk about this in terms of what we're most likely going to be dealing with day to day in practicing real estate. If you've got multiple owners of a property that's getting ready to be purchased, who is it usually typically going to be? A husband and wife, right? Multiple owners usually will be husband and wife. Well, now you got a decision to make. Do you want to buy this property, couple, as joint tenants or do you want to be tenants in common? They can do it either way. But here's why this really matters. Why it's such a big deal. If it's tenants in common, if that's how it's listed when you buy it, that means the husband's going to get a 50% share and the wife's going to get a 50% share unless they decide to do it unequal, which is not likely. They both have their own title. You also say the husband dies. Hopefully the husband, because he loves his wife, just decided to leave his interest to his wife. But he doesn't have to. He might leave it to one of his children or somebody else, for crying out loud. I promise you, sweetie pie not going to be happy. You might have thought you were just going to be buried in a casket, but she might decide to cremate you. Anyway. Bad things could happen here. I say bad things. Some things that are unintentional, which could be bad things, could happen, and not that necessarily the deceased husband meant to create these problems for the wife he's leaving behind, widow. But it could cause problems. If that husband died in debt, owing a lot of money, now then the probate courts, they could liquidate the house. They could take the house and sell it, leaving your widowed wife homeless, basically. So there's some really bad, potentially unintended consequences if you make the wrong choice on the types of tenancy. Because if they bought the property and declared they wanted to be joint tenants, that changes everything in that scenario. As joint tenants, if one spouse dies, then ownership goes to the other spouse, 100% of all of it. They own it. Now probate can't touch it because the property that he did own, he no longer owns, because upon the death of one of the owners, because of the right of survivorship, the remaining spouse now owns all of it themselves. So the judge can't take somebody else's property and say, sell it because we need to pay off this person's debt. You can't do that. So there's a lot more protection, especially for couples, if it's purchased as joint tenants versus tenants in common. But I will tell you, this is just my opinion, and I'm certainly not giving legal advice. But I think about the only time, if I'm going to be buying property or owning property with multiple owners, other owners, the only time I would ever even consider joint tenancy is if it's husband and wife. Other than that, I don't want to be stuck with two parties. We might be best friends today, but you never know what our relationship be like tomorrow. You know that. So, that could create some issues for sure. But now let's talk about this partitioning. Here's where it comes into play. Say it was, again, me and my two partners. We bought the property as joint tenants. I want out. Maybe I'm not getting along as well with my partners as I was when we initially bought it. So I want out of this deal. Well, can I just walk away? No. In fact, now you can't do anything without all three of you, all the partners agreeing on what you're going to do, whether it be sell it or what. Your partners might say, we're not letting you out. We're not going to let you sell your interest. You're stuck with us and you're staying with us. Now you could potentially go to court, and this is where partitioning really becomes of importance. Now I will tell you, this is not automatic, okay? You should never be going to court to sue to have the title partitioned, and I'll explain that here in a little better here in just a second. But this is not something automatic. You're going to have to basically prove your case to the court. You can't just decide because I don't want to do this no more, I want out. That ain't going to work. Now, if you can prove to the court that you're experiencing some kind of hardship, maybe caused directly because of what your partners are doing, they're causing you a hardship, they're causing you to lose money, whatever. If you can show that or prove that, then the courts will likely agree to partition the property. Now, what does that mean? That means they're going to say, all right, because there's 3 of you, now we're going to divide up the interest equally. Meaning each partner will own 33 1/3% interest, right? So in essence, when they say we will partition the property, say I'm the one seeking to partition, I want out of this deal. Then they'll redo the title work. I will now receive my own title that just has just my name on it, showing that I own 33 1/3% interest. Now the other 2 partners, they're going to get one title with both of their names still on it, but it will show that they own the remaining 2/3 interest, right? Well, wait a minute. How come I've got a separate title, but they did not get separate? They each got one title with both their names on it. What are we dealing with here? That means my 2 partners are now still joint tenants, but as joint tenants, they only own 2/3 interest. But because I was partitioned out, I now have my own title, just my name. That makes me a tenant in common. Because we're still multiple owners, but I'm now a tenant in common, owning 1/3 interest. Now I can sell my interest or whatever it is I want to do with it. Okay? So hopefully that makes sense. I would say after all that, I would say, the main thing to remember between joint tenants in common can have undivided interest. You do not have to own the same amount. Joint tenants, you cannot divide up the interest. However many partners, you now own it all together, period. And I'd also be familiar with that joint tenancy must always come with the right of survivorship. All right, now, we've listed here 4 unities of joint tenancy, and we've really already talked about all of them. But if they ask you on the exam, and they could, what are the unities of joint tenancy? You've got unity of time, title, interest, and possession. In other words, you all have it all together. All of the time, title, interest, possession, right? You must all own it at the same time and during the same time. You all own one title. You all have own the whole interest, right? You can't divide it up. And you all have the right to possess whatever, the property that you're buying. Okay. And then another type of tenancy, again, still freehold tenancy, is now this tenancy by the entirety. Now, I will tell you, not every state recognizes, recognize this type of tenancy. Some do, some don't. But what is tenancy by the entirety? Well, first of all, you'll notice the main requirement here, you must be husband and wife. You cannot be a tenant by entirety unless you're married, husband and wife. Okay? Now, beyond that, this type of tenancy works exactly like joint tenancy. There is no difference between joint tenancy and tenancy by the entirety. There's nothing different about the two, with the exception, tenancy by the entirety requires you to be husband and wife. Joint tenancy, you can be husband and wife, but you don't have to be. That's the only difference, okay? So, if they're asking you a test question, and the way they describe the situation in that question is clearly joint tenancy, especially if it says things like the right of survivorship, You cannot divide the interest, y'all, stuff like that. You know that is joint tenancy. But it also clearly states in there, husband and wife. Husband and wife. Y'all, that's probably the key that they're expecting you to choose tenancy by the entirety. Okay? But y'all, potentially it could say husband and wife, and tenancy by the entirety is not even an option. Then guess what the option or the correct answer would be? Then it would have to just be joint tenancy. Because it could be either way. But anyway, y'all, hopefully that's clear. Y'all, still on this tenancy by the entirety, y'all, again, this is something that some states recognize, not every state, but something called community property. Y'all, meaning, y'all, the states that recognize community property means that basically anything that was owned prior to marriage, y'all, we're talking about the husband and wife. Y'all, anything the husband owned prior to getting married still belongs to the husband after they get married. Anything owned by the wife before they got married will still belong to the wife after they get married. But anything they own, purchase, acquire during the marriage now becomes community property. Now they both own it. Okay? Y'all, some states will recognize that theory. Some states don't. I will tell you, a lot of states, they say once you get married, what's hers is hers and what's yours is hers. Y'all, basically, I'm being funny again, but anyway, moving on. I don't want to get in trouble. So now we need to take a look at these life estates. Y'all, and y'all, this is really exactly what it sounds like. A life estate is based and founded on the life of somebody. Okay? So we're going to take a look at how they work, because there are different types of life estate. So depending on your scenario or your situation, obviously will have a lot to do with which type of life estate might work best for you. But y'all, I'm going to tell you, these are critical. I'm surprised that more people do not create these life estates. And the only reason I can think that they don't is because they don't understand, they don't know about them, or they don't understand them, they don't know what you need them for. So hopefully this will be a little bit informative for you. But there's really two major types of life estates. They're either considered conventional life estates or legal life estates. And we're going to talk about both types, but we're going to start with the conventional. Y'all, there's really about two different types of conventional life estates. And the first is what is called an ordinary life estate, which, y'all, I think that's a really good name for that estate because it is very ordinary. But as it says here, y'all, this is where you have an estate that's based on the life of the grantee. Y'all, for example, I'll use my mom for an example. Y'all, my mom, before she passed, y'all, she converted her house. Y'all, she had a house, but she converted it into a life estate, meaning it was hers for as long as she lives. Obviously, so that means she could stay there. She stayed there for as long as she lived. But the moment she died, y'all, in a life estate, you have to identify somebody we call a remainder man. Y'all, we'll talk more about that term here in a little bit. But y'all, a remainder man basically is a third party. Y'all, that is somebody named in the estate that will receive or own the estate once the life tenant dies. Y'all, so in this example, if it was my mom, y'all, she converted her home into a life estate, and I'll explain why that's important, why it matters here in a little bit. But she converted it into a life estate and then put in the estate that upon her death, y'all, because once you turn it into a life estate, now that, y'all, my mom, y'all, the terminology that would be used, y'all, she's now considered a life tenant. life tenant. If you're the life tenant, that means you still own the property for as long as you're alive. After you die, you don't own it. Why does that matter? Because if you're the life tenant, could you have in your will who you're going to leave the house to? No. No, because you turned it into a life estate, which means you do not have any ownership the moment you die. You can't say, I'm giving it to Billy Bob, because you don't own it after you die. You can't make that decision. It's a life estate. So that's why it's named in the estate who will get the property when the life tenant dies. Okay, now why would you even want to do something like that? I don't want to get into a whole lot of detail here, but just a real quick, I'll try to make this a quick example because I think it's important, and unfortunately a lot of people deal with this kind of thing. My mom years ago was diagnosed with dementia. Seems to be a common thing. A lot of people have dementia, Alzheimer's, stuff like that. And quite frankly, she had both, Alzheimer's and dementia. But we knew there would come a time when she could no longer live by herself, which at the time she was living in her house by herself. And we had a friend that was also an attorney, and once she was diagnosed with that, he told me, he said, Frankie, you need to have your mom move her house into a life estate. Now I will tell you, at the time when he told me that, I had no idea what it meant. Didn't know why we should do it, but look, he was a friend of ours. He's also an attorney. I trust, so we just did it. But here's why this became such a big deal. The time finally came that she had, she could not stay there. We had to get her into an assisted living. And if you've ever looked into something like that for elderly parents, you'll find it is very, very expensive, or certainly can be. And now if you've got the money and you can write that $5,000-$10,000 check per month for them to stay there, awesome. You've got no worries anyway. But we weren't in that situation. We couldn't pay for that. So basically what the facility required, under this particular program that we were working with, everything she owned had to be sold. Everything had to be sold, and obviously went to the assisted living. They got all that money, and then we did have to pay however much every month, but it wasn't near what it would have been, the $5,000 or more dollars per month. So that helped a lot. But the biggie here, and the reason I'm telling you this, they could not take her house. They could not require her to sell the house to move in under this program because it was in a life estate. Meaning when she died, it immediately went to me and my brother. That's it. And there's nothing they can do about it. So they could not touch her house. Had we not put that in a life estate, then they would have taken the house. We did have to sell her car and stuff like that. Everything else she owned. But they could not take her house because it was in a life estate. That was critical. Now we'll tell you, and again, I don't want to get in a lot of detail. This is not something you can wait and do at the last minute, because there is, and I forget the exact time, but I think it's like a 5-year look back period where, if they were to look back 5 years in the past and see that she actually converted the house to a life estate within the last 5 years, then the deal is a no-go. Whatever the value of that house is will have to be paid in this case, to the assisted living facility. So this is something you want to do well in advance to make sure that by the time they do have to do something like this, there's nothing that took place within that, whatever the look back period is. It might be 7 years, but I think it's 5 years. I think that's right. So Anyway, y'all, life estates are important for all kind of reasons. I'd encourage you to look into it some more. But for test purposes, just know a life estate, or at least an ordinary life estate, is just an estate that's based on the life of the person that's living there. Whoever's currently living there means they are the life tenant. There's nothing anybody else can do with them. They can't take the house from them. Y'all, they have to be allowed to stay there for as long as they're alive. But after they die, then the property goes to wherever it's stated in the life estate. All right, moving on. Y'all, you could have an estate per ultra V. Y'all, again, that's how we pronounce it in South Carolina. Y'all want to pronounce it some other way if you live somewhere else, then God bless you. Per ultra V, or per ultra V, y'all, something like that. Y'all, this one's a little bit different. It's kind of interesting, but it's absolutely different. But y'all, this is where, I might say, all right, John, you are the life tenant. Okay? But your job, y'all, let me do it this way. Y'all, because this is how you see it used a lot. Y'all, say you got an elderly couple, obviously getting up in years, and maybe to the point where they can still stay at home by themselves, y'all, the two of them. But they do need some assisted living a little bit. Y'all, maybe they got people coming in to try to, take care of them, feed them, whatever. Well, say the husband dies, he may decide, maybe they've got to live in nurse that, that comes in each day or whatever for so many hours and takes care of them or whatever. Then say John is the husband. John dies. Well, when he dies, he may have it already set up so that everything he owns, his entire estate, will actually go to the live-in nurse. The nurse now owns the house, everything, y'all, the entire estate. Y'all, if there's any income coming in, the nurse owns all of it. Well, that's kind of interesting, isn't it? He left everything to the nurse. Well, but here's how this worked. With an estate per ultra V, basically what he's saying is this: nurse, it's all yours for as long as my wife is still alive. But the day she dies, nurse, you're out of here. You no longer own any of this. So basically, with an estate per ultra V, the ownership is based on the life of someone other than the person receiving the benefits for it. The reason he might do that is because, if that nurse knows the day she dies, I'm out of here. I don't get to control everything or have the money coming in or whatever. She might be a little more inclined to take very good care of the wife as long as she can. We want to keep the wife alive as long as possible, right? That's kind of how the estate per ultra V works. So in a nutshell, that means you have, the life tenant is someone other than the one receiving the benefits. So in this example, the nurse is receiving all the benefits, but only for as long as somebody else is alive. In this example, the wife. So that's a little bit interesting there. It's a little bit different for sure. But now we take a look at the legal life estates. Obviously, these are created by law, not by an agreement, but they protect the property rights of surviving family members upon the death of the husband or wife. Now, there's different types here. Now, I'm going to tell you, I don't have many, if any, people coming back telling me that they got any questions about legal life estates. But just in case, I'm going to go over them real quick. I'm just not going to spend nearly as much time on them. But, with these legal life estates, one could be what we call the homestead. And it said the will only applies to a primary resident. You can only claim homestead on your primary home, where you live. If you own other properties, beach property, or vacation home, whatever, you cannot claim homestead on any of those properties. But what it does protect family members from creditors. Could even prevent probate from requiring you to sell it to pay off some of these creditors. That's what homestead does. Then there's what we call the dower and curtsy. And again, and this is not even recognized probably in a lot of states anyway. But the term, really the only thing you might want to remember here if they even ask you this, what is dower and what is curtsy? It says dower is the wife's interest in the husband's property. Curtsy is the husband's interest in the wife's property. Okay? Then obviously if one party dies, then the other party owns all the interest themselves. That's dower and curtsy. But not every state will recognize that. You could have this, what we call elective share. Again, not recognized in a lot of states, but just so you know what it is. It says it allows for a surviving spouse to make claims to a deceased spouse when the deceased spouse did not include the surviving spouse in their will. That's pretty sad. That is pretty sad when something like that happens. But maybe when they bought the house, if they bought it as joint tenants, this would not be an issue anyway, which is probably why elective share, dower and curtsy, a lot of that kind of stuff, if not most states, certainly a lot of states, maybe most states don't even recognize that. But anyway. But then, we need to talk about some future interest in life estates. There's 2 future interests, and you better note these. These are important. Number 1 is reversion. So typically when you have a life estate, we might keep a reversionary interest. So just to give you another example, maybe, say I've got a daughter. And my daughter needs a place to stay. I just happen to have another property. Maybe I was renting it out at the time, but my daughter needs a place to live. So I say, look, I'll give you this house. You can have it, but as a life estate, meaning it's yours for as long as you are alive. So don't plan. You can't sell it, or I'm not going to let you do whatever you want to do with it. I say, they could potentially sell it, but I'm not going to go down that road. That's another rabbit trail. But when you die, it's going to go to whoever I say it goes to. You're not going to have any say so, because we're going to set it up as a life estate, meaning it's yours for as long as you are alive. You can do whatever you want to do with it for as long as you're alive. Well, one of the things I'll probably put in that life estate is I will probably state that I will retain a reversionary interest. Meaning, if she should die before I die, then it'll just revert right back to me, as the original owner. That's a reversionary interest. Now, I will not get it back. Once you give it to them as a life estate, you ain't getting it back unless they die first. Now, if they die first, now you got some options here. One is a reversionary interest where it could just revert back to you. The other type of future interest is remainder. This is the one we really need to make sure you understand. The remainder interest is someone named in their life estate to receive the property. This is other than the original owner. So if I'm the original owner, I may retain that reversionary interest, meaning I'll get it. It'll come right back to me if they die before I do. But if I die first, and then, in this case, my daughter dies, then I will have already named a remainder man, someone with remainder interest in the estate that says it will go to that person when, in this case, the life tenant or my daughter dies. I hope that wasn't too confusing. But here's why this is a big deal, and you really need to understand this. Is it possible that whoever the remainder man is, we know the remainder man is someone with remainder interest. Means they will receive the property one day in the future. And that'll be whatever day the life tenant dies. Well, is it possible the remainder man does not like how the life tenant is taking care of the property? Maybe they're not taking care of the property at all. They're not maintaining the property. It's just going downhill. And I don't want to see it go downhill because I'm going to be owning it one day. Is there anything I can do about it? No. The remainder man has zero control over that property as the remainder man. Because if you're the remainder man, you don't own the property. You don't have any more control over that property than anybody else does. All we know is as a remainder man, you will own it one day, but that ain't today, right? So, here's why this is important. What you want to be careful of, when you get ready to take the exam, or if you see questions on the test here. If in the question it states, so-and-so, say John, for example, is the remainder man of such and such a property, or it might read has remainder interest of such and such property. And the life tenant is doing whatever they're doing, and John doesn't like it. Is there anything John can do about it? Here's the key thing you need to be paying attention to. If it states that somebody has remainder interest, what should that tell you about the life tenant? That means the life tenant is still alive. And obviously if the life tenant's alive, then there's nothing John can do about anything. Because see, here's what happens, and I don't want to get too graphic here, but the second the life tenant died, the moment that person's heart quits beating, remainder interest goes away. It disappears. It no longer exists. It's an instantaneous thing. Life tenant dies, boom. Remainder interest does not even exist anymore. Because at the moment the person died, remainder interest disappears, but it's replaced with fee simple ownership. Okay? So obviously if the question's asking or stating that someone has remainder interest, then that means the life tenant's still alive. Because if the life tenant has died, then there is no more remainder interest. So just be careful of that. So again, basically, can someone with remainder interest do anything or have any say-so over that property? None. Not while they have remainder interest. Can't happen. So hopefully that makes sense. There's at least those type of life estates. We'll talk about the other ones here in just a second.